sir, your thoughts on the decision of the president to reject the list of nominees?
A convenient place to begin, perhaps, is to start in 1991 when President Carter persuaded President Desmond Hoyt to amend the law and to use a new formula for the elections, for the appointment of a chairman of the Elections Commission. At that time, the president alone could have appointed a person to act as chairman of the Elections Commission. And the, the qualifications then was a person who either was qualified to be a judge, was a judge, or was a former judge, meaning a court of appeal or a high court judge. That was the position pre 1992. President Carter persuaded President Desmond Hoyt to change that formula and came up with a formula. And that formula was that the leader of the opposition will submit a list to the president after meaningful consultation with the other parliamentary parties. And on that list, the president is to choose one person. At that time, the qualifications were not mentioned. And as a result, Dr. Jagan submitted such a list to the president. The list also must be one that the president finds acceptable. And 6 names were submitted by President Jagan, from which Mr. Hoyt chose one. The 6 names, if I can give you them, that was submitted by Dr. Jagan in 1991 was as follows: David Yankana, Bryn Pollard, Rudy Collins, Joey King, and Ronald Locke. President Hoyt chose Ambassador Rudy Collins. Then we had in 94 local government elections, and we had to get a chairman for that elections commission as well. For the first time, the formula or the requirement or the qualification of a fit and proper person was added to the Carter formula. And a list was submitted again, this time by leader of the opposition, Desmond Hoyt, to President Jagan. And President Jagan chose Edward Hopkinson. Then, in 1997, for the 97 elections, a list was submitted by Mr. Hoyt to then President Jagan. On that list were the following names: Dudnath Singh, Edward Hopkinson, Justice James Patterson, Mr. Rudolph Harper, former Chief Justice, Charles Libord, and Randolph Corton. President Jagan chose Mr. Dudnath Singh. And then it continued to 2000 for the purpose of the 2001 elections. And that list, which was submitted by Mr. Hoyt to President Jack Day this time, that list consisted of Major General Joe Singh, Rudolph Harper, Dennis Craig, David Granger, Jem Fletcher, and Harold Davies. And then for 2006, another list was submitted, this time by Leader of the Opposition Corbyn, to President Jagdev. And from that list, President Jagdev chose Steve Surajbali. So those are the names that have been used over the years. And the constitutional requirements are very clear. One, the person must either be a judge, be qualified to be a judge, or a former judge, either of the High Court or the Court of Appeal. That's one set of qualifications. Or a fit and proper person. Of the names that I have called, you will realize of all the persons who have thus far served as chairman of the Elections Commission, only Dood Not Singh had legal qualifications, and therefore only Mr. Dood Not Singh could have qualified as a person qualified to be appointed a judge, because of course he was not a judge of the High Court, he was not a judge of the Court of Appeal, nor was he a former judge of the High Court, nor former judge of the Court of Appeal. The argument advanced by the President that the requirements seem to be that a judge or a person qualified to be a judge is the only qualification for a person to be possessed of, to be appointed chairman of the Elections Commission, is obviously an inaccurate and misguided argument. The Constitution has two sets of qualifications. And over the years, the fit and proper person qualification is the one that has been used. The fact that Mr. Granger himself was among the nominees in 2001 is by itself shows that his argument is wrong, because he's not qualified to be a judge, he's not a former judge, and therefore I don't understand his argument. Is he now saying that Mr. Hoyt violated the Constitution by nominating his name? Is he saying that he violated the Constitution by accepting the nomination? Because obviously he would have had to agree for his name to be put on the list. So I think that the President is playing some sort of game. Mr. Desmond Hoyt was a senior counsel of great eminence, and I have the highest regard for Mr. Hoyt's legal acumen. And so Mr. Hoyt understood what the requirements were and made submissions based upon the constitutional, and that is why he submitted a list on which was Dr. Steve Surajbali, who is not qualified to be a judge, is not or was never a judge either of the High Court or the Court of Appeal. So I mean, Mr. Granger has to come up with something more sensible if he's going to reject these names and have that decision find acceptance with the intelligent mind, or acceptance by the intelligent mind.
Do you think this is enough to put someone close to the party in that position?
I have pointed out already that this is the first time that a president would have rejected a list coming from the leader of the opposition since this formula was initiated in 1992. So this is an unprecedented move. And in my view, I think the president wants to reject these lists and then claim that no proper list was submitted to him, and therefore he can appoint a person of his own choice. That would be a travesty, and that would be a violation of the letter and spirit of the Constitution. Fundamentally, when President Carter conceived and designed this formula, it is obvious that he intended to put forward a mechanism that would have achieved consensus between the opposition and the president. That is why the list originates from the opposition but must find acceptability of the president. So, inherent in a list or inherent in an appointee to that position would be a person that would have enjoyed the support of both the opposition because they put forward the name in the first place, as well as it would have found acceptance by the president. So you would have had, in essence, a consensual candidate. This president obviously wants to violate, in my humble view, that formula and wants to violate the letter and spirit of the Constitution. If he's right, then any president can easily reject all the names submitted capriciously and arbitrarily and then claim, well, no proper list was submitted to me and I must appoint my own person. That could have never been what the framers of this formula intended. It could have never been what the framers of the Constitution intended when they put that formula in the Constitution in 1995. It was put there in 1995 and kept there after the constitutional reform process. And I wrote a long article just a week ago outlining all these matters.
Can this be linked or can this affect free and fair election?
Of course, I interpret this as the first clear signal of an intention to rig the 2020 general and regional elections. We all know that the PNC has a history of rigging elections. The world knows that. And here it is, the first time that they are ever holding the reins of government. They want to interfere with the democratic structures and constitutional mechanisms which are there to protect our democracy and to prevent the rigging of elections. They want to install a person, obviously, that they would want to manipulate. Significantly, you will note that this government is doing nothing to win the minds of the Guyanese people. They are pursuing one set of unpopular policies after another. No government that is interested in winning an elections fairly would ever impose over 200 tax measures on a population in a singular calendar year. This government is doing it brazenly. No government that wants to win a free and fair election will raise employees' salaries by 5%, but raise their own salary by 50%. No government that wants to win an election free and fairly would engage in the type of squandermania and corruption that we are seeing this government is engaging in. No government that wants to win a free and fair election will impose increase in fees, public fees for public licenses, increase it by 50,000%, but raise salary by 5%. It means that that government, such a government, obviously has another plan to get into government and to stay in government. And that plan, obviously, is to compromise, rig, and manipulate the next elections. And we are seeing the seeds being sown for that to take place. And I say this and I appeal not only to, this is not about party politics anymore. This is about the future of our country. Do we want to go back along a path where a government is no longer answerable to the people? That they don't depend upon the people's vote to stay in government? That they can do what they want to the population because they have a guarantee of staying in government by rigging of elections? Do we want to go back to that? Well, it is the people to decide. But what I know is that we are seeing the foundations being laid for that here. And we intend to internationalize it, we intend to expose it, and if necessary, we intend to challenge it in the courts of law.
Just digressing a bit, your thoughts on the president claiming that he will not give up state properties, specifically Red House?
The, Nobody's asking the president to give up state properties. Nobody's asking the president or the state to give up Red House. We are asking the state to respect the laws of the country. Red House has a lease for 99 years, and we are asking the government to respect that lease. Thousands, hundreds of thousands of people have leases of state property. We are not asking the president, certainly, not to give up all those leases and to give up state lands. We are asking him to honor those leases. If he believes that they should be rescinded, then rescind them in accordance with law and evict the tenants from these premises in accordance with law. That is what the rule of law means. And we are a society, hopefully, that is still governed by the rule of law. So the president has this whole thing wrong.
Is there anything else you'd like to add, sir?
No, that's it.